Today, we are going to be discussing a motion in limine that was filed in the Donna Adelson case. Donna Adelson is a case that I have been following from day one of Donna Adelson's indictment, and I'm keeping track of the docket. There just hasn't been too much new information or exciting information to report on, so I'm really focusing a lot of my efforts to other cases. But this was a motion in limine that caught my attention, and that's why I want to discuss it today. So to kind of get caught up on the backstory where we are in the Donna Adelson case, Donna Adelson was initially represented by a fellow named Dan Rashbaum. Dan Rashbaum also represented Charlie Adelson. Charlie Adelson was ultimately convicted, and he is now serving a life sentence without the possibility of parole. His case is currently in appeal. And one of the issues that is most likely going to be brought up in the appeal is the claim of ineffective assistance of counsel. Reason being that Dan Rashbaum was also representing Donna Adelson at the same time that he was representing Charlie Adelson. And if he took any action in Charlie Adelson's case to protect Donna Adelson's interest, well, that can be a claim of ineffective assistance of counsel. So that is going to be an issue most likely on appeal. And if not during the appeal, then perhaps in a motion after the appeals have been exhausted. So that has yet to be seen. Now, Dan Rashbaum did represent Donna Adelson up until the day of her trial. On the day of her trial, there were some motions filed, and he was ultimately thrown off the case because Charlie Adelson was actually listed as a witness, a Category A witness on the state's witness list. And he cannot cross-examine Charlie Adelson if Charlie Adelson was his previous client. So he was thrown off the case, and that's where all these questions about whether he was conflicted out of representing Charlie Adelson in the first place came up. Well, Dan Rashbaum was thrown off the case, and Donna Adelson had to retain new counsel. The trial was pushed off, and now this trial is scheduled for September 30th, 2025. So perhaps as trial gets closer, perhaps things will heat up on the docket. Well, initially, Dan Rashbaum filed a motion in limine before the first trial was supposed to occur in Donna Adelson's case. And this is a motion now that was filed by their new counsel, by Donna Adelson's new counsel, and essentially asking the judge to reconsider his ruling, which he made in that initial motion that was filed by Dan Rashbaum and that was argued by Dan Rashbaum. So in order to really understand the full context, what I'm going to do, it's not too long, I'm going to pull up Dan Rashbaum's motion in limine. I'm going to read parts of it. It's really a short part. Then we're going to play the video of the oral argument, which again is not too long. And then we'll get into the motion in limine, or the renewed motion in limine that was filed by Donna Adelson's new counsel. And then we're going to discuss it like we always do. So let's pull it up. But before we do, I do want to remind everybody that tomorrow, March 25th at 11 a.m., there is a very important hearing in Karen Reed's case. I will be live streaming it. So definitely join me right here at Brother Counsel Studios when we will be live streaming that court hearing, March 25th, 11 a.m., and I'll be giving you my real-time analysis. So without any further ado, let's pull up Dan Rashbaum's motion in limine, which was filed way back, and then we'll slowly move forward till where we get to the motion in limine that was filed recently by Donna Adelson's new counsel. So here we go. This is Dan Rashbaum's motion. During Charles Adelson's trial, the state questioned Wendi Adelson about, number one, the characters and storyline of a fictional book that Wendi authored about human trafficking. 2, name changes of her children. 3, Wendi's willingness to allow Professor Markel's parents to visit with their sons since 2014. And relatedly, number 4, the Markel's successful efforts since 2014 to lobby for the amendment of Florida's grandparental visitation rights. The substance of Wendi's fictional book, written years before Professor Markel's death, name changes for her children, visitation decisions she may have made in the wake of Professor Markel's death, and legislation enacted in response to his death have no probative value to the only question this jury will be asked to decide: Donna Adelson's guilt or innocence on the crimes charged. So his first argument here is that it's just simply not relevant. It's not relevant. The first thing that you have to prove if you want to admit evidence in a trial is that the evidence is relevant. You can't just admit whatever you want. It has to be some sort of relevance to where the ultimate question is whether Donna Adelson is guilty or innocent. So therefore, his first argument is that it's not relevant at all. Number 2, any conceivable probative value of this evidence value is substantially outweighed by the danger of unfair prejudice and should therefore be excluded. So this is what we call the 403 argument. The 403 argument is a very, very common argument that's used, and that is that even if the Commonwealth can show that there is some sort of relevancy to Wendi Adelson's book and some of these other issues here. But if the danger of unfair prejudice substantially outweighs the probative value, well, then it should also be excluded. So number one, his argument is it's not relevant. Number two, even if it's relevant, the danger of unfair prejudice is substantially outweighs any sort of probative value. And that's it. So that's his motion. It's a 403. Essentially, it's a 403 and also relevancy argument. And that was his argument there. So now let's go now to the actual court hearing where the arguments played out. Here we go. And I put it on a little bit faster just so we can get through it a little bit quicker. It's not too long, but here it is.
With regards to before, the state's position may or may not have changed. Positions are possibly changing. So here we're trying to prevent certain statements, certain questions from being asked to Wendi Adelson based on relevancy grounds. So the first one is questions about her book regarding human trafficking. We can't for the life of us explain how that would have anything to do with Donna Adelson's trial for first-degree murder. The second one is Wendy's, the name changes of her children. There's never been any testimony that those name changes have anything to do with Donna Adelson. We don't know how that could have anything to do, again, with this case. The third is Wendy's willingness to allow Professor Markel's parents to visit their grandchildren since 2014. These statements have nothing to do with this case and in fact are used to prejudice the jury against our client, even though it has nothing to do with her. And the fourth is, and it came up in the last trial, asking about the Florida grandparental visitation rights law. I think that is one that the state has agreed to not ask about, but they go back and forth, so I'm not sure. So, but I think that is one. Again, these questions have very little to no probative value, and they're done to prejudice a jury. And so under a standard of 403, they should not be allowed.
Sure. Well, also one point with this line of questioning, I'll hear the state's position, but I'll make clear on this. I understand Ms. Adelson is a member of the bar. However, if any testimony is permitted on this point, she is not to be opining on the Florida statutes and the validity of. Is everyone clear on those?
Yes, Your Honor.
Go ahead, Ms. Kaplan.
I think in reference to the
So just something that Judge Everett just mentioned, he said that even though that Wendi Adelson is a lawyer, but she's not going to be allowed to opine on the validity of these statutes, these specific statutes that were enacted in Florida. That's not really what she's supposed to be doing on the stand. So he just wanted to make that mention, even though it really had very little to do with the actual motion in front of him.
The book, this is the one I kind of flip-flopped on because I went back and looked at how it came up last time, which was that Wendi Adelson denied wanting to relocate, denied being disappointed about losing her motion in court to relocate. And that is, of course, the state's theory as the main motive behind this crime was that she was wanting to relocate to South Florida. And I thought at the time, that testimony opened the door to her having written a clearly autobiographical book about a woman just like herself, married to a man just like Dan Markel, who's utterly miserable and stuck in the place that she's living in. So if the testimony goes that way this time, I can imagine a scenario where I might want to ask about that. I'm fine with approaching, if Your Honor prefers that, to see if we think we're there, where I can inquire about that. There's a high likelihood I might not want to inquire about it at all. So however you want to handle that one. In reference to...
So I got to remember the big motive here is that Wendi Adelson wanted to get out of Tallahassee. She wanted to relocate to where her parents live. And the problem with that is that the children were stuck in Tallahassee, according to her. And she wanted to move with the children. Tallahassee is not such a close drive to where her parents live. So a lot of this has to do with her wanting to relocate, which could have been part of the motive for the murder. Now, if in this book itself, it talks about a lady who is stuck in a place where she doesn't want to go. And of course, it's a fictional book. But what the argument here is by Georgia Koppelman is that, you know, she was writing about her own story, that these people that she's stuck in this terrible relationship and she's stuck there because of the kids and she really wants to relocate. And that's what that's all about. Now, Wendi Adelson testified to the last trial that no, she had no problem. She was no problem with Tallahassee. She didn't want to relocate. Everything was great. So the book can be used to kind of impeach that and show her that, well, you were writing this book about some fictional character who seems to be very similar to you, who really wanted to relocate. So that's why she would want to bring in this book.
The other two items, I think those go to the state's theory that this crime was done in order for Wendi to move to South Florida with these boys and to erase their father and his family from their lives. And there's a lot of evidence of that, and that's part of the failure to provide access to the children to his grandparents and the name changes. So these kids were 2 and 3 at the time, and it's the state's theory that the effort was to eliminate their father, not just physically.
Right, as to that point, Ms. Kappelman, I understand the relocation and the divorce proceedings as it plays into the state's theory. But ultimately, was it not Mrs. Adelson's right as the parent and guardian of the children to change names or make certain parental decisions after the other parent has deceased?
Absolutely, Judge, but those decisions might be relevant.
So her decision to change their names after her husband was deceased, whether she had anything to do with that or not, obviously would be her decision to do. That is her right to do. She's the parent. She can change their names.
To the state's theory in the murder. I'm not alleging that she's done anything illegal, but I think it's relevant to the consideration of whether or not this murder was done. It's inconsistent with what you would expect a parent to do on the heels of the murder of their father. Right? So I think a reasonable juror could infer something from that and should be permitted to do so if they find it compelling.
Any further argument as to this issue?
No, Your Honor.
Just one briefly.
Go ahead.
Wendi Adelson is not trial. So, I mean, this may be a different topic if this were the trial of Wendi Adelson, but this is the trial of Donna Adelson. And what they're trying to do is they're trying to dirty up Donna Adelson based on decisions, either fair or not fair, that Wendi Adelson made. And again, that is, again, it doesn't fit, I don't think it fits the relevancy standard, but even if you get there, when you do a balancing test, they're going to be able to show, and they're going to do a pretty good job of trying to show what the divorce situation looked like and how Donna Adelson wanted relocation. I mean, they're going to be able to do that. So just adding this to the fire is, if in any way relevant, is when you do that balancing test, I don't even think it's close, Your Honor, for any of these conclusions.
All right. Well, that is essentially the argument. And Judge Everett ultimately decided that it will be admissible for impeachment purposes. So now that order was in, so now this is where the motion in limine that was just filed again by Donna Adelson's new defense team, where they're asking the judge to reconsider his order on that. So let's pull up their motion in limine now. And here we go. Not too long of a motion in limine, so we'll just get through it pretty quickly, and we'll talk about it. Defendant Donna Adelson, by and through her undersigned counsel, pursuant to sections 401, 402, and 403 Florida statutes, renews her request that this honorable court prohibit the state from questioning Wendi Adelson about the storyline of her book, and in support thereof states as follows. Mrs. Adelson has been indicted in this case with 1 count of first-degree murder, 1 count of conspiracy to commit first-degree murder, and 1 count of solicitation of first-degree murder. Prior defense counsel moved to prohibit the state from questioning Wendi Adelson about the storyline of her book, This Is Our Story. On September 6th, 2024, the court denied this prong of the August 12th, 2024 motion in limine, ruling that the state could use the storyline for purposes of impeachment. So that was the initial order after all the motion in limine and after the oral argument that we just watched. Current counsel renews the motion in limine as additional facts were not previously known and or addressed. So what we always talk about on this channel is that when you want the judge to reconsider something, so you can't just ask the judge, hey, can you reconsider that? We don't really like that ruling. You have to provide some additional facts that were not previously known at the previous hearing. So this is what the her new defense counsel purports to do right now, is to say, look, there's some additional facts, Judge Everett, that you did not know, you're not aware of, and now, therefore, this is the basis for you to reconsider this motion and not allow any sort of mention of this book at all when Wendi Adelson is on the stand. During the August 30th, 2024 hearing, so that's the hearing that we just played, the state argued the following. And we just heard this. I think in reference to the book, this is the one I kind of flip-flopped on because I went back and looked at how it came up last time, which was that Wendi Adelson denied wanting to relocate, denied being disappointed about losing her motion in court to relocate. And that is, of course, the state's theory as the main motive behind this crime was that she was wanting to relocate to South Florida. And I thought at the time that testimony opened the door to her having written a clearly autobiographical book about a woman just like herself, married to a man just like Dan Markel, who's utterly miserable and stuck in the place that she's living in. So if the testimony goes that way this time, I can imagine a scenario where I might want to ask about that. So this is exactly what we discussed, why she would bring up this book for impeachment purposes in case Wendi Adelson says that she was completely fine and happy living in Tallahassee. She never really wanted to relocate. She just loved Tallahassee to death. All right. The petition for dissolution of marriage was filed on September 10th, 2012. The motion for temporary relocation and amended petition adding the count for relocation was filed on January 14th, 2013. Okay, so this is where the Wendi Adelson was asking the court to relocate, meaning relocate herself and her children. January 14th, 2013, the petition for relocation was denied on June 18th, 2013. And this is where she can be a little upset about not being able to relocate. The evidence establishes that Ms. Adelson's book was originally published on September 15th, 2011. So her book was published 2011. Now here, the argument is going to be that if the book was published 2011, and she's really just all upset that this petition for relocation was denied, well, the book came out before the petition for relocation was denied. So how can you use this as a basis to say, well, look, you're writing about yourself and how upset you are about where you are. Well, this was in September 2011 when you wrote that book, and this petition wasn't denied until 2013. Even assuming the storyline of Ms. Adelson's book is autobiographical, how Ms. Adelson felt about being stuck in Tallahassee at the time she wrote the book is not relevant to how she felt after a petition for relocation was denied or during the time of the alleged conspiracy, right? Because that's part of the argument here from the state, from Georgia Kaufman, is that, she was just so upset about this petition being denied, and that's why she wrote this book. Presumably, Ms. Adelson did not start writing this book in September 2011. Rather, it is significantly more logical that Ms. Adelson wrote the book over a period of time, which concluded in September 2011, right? You don't just write a book in 3 days, making it even more remote in time to the denial of her petition for relocation. As a result, even if marginally relevant, it does not survive a Section 90.403 Florida statutes analysis, as its probative value is substantially outweighed by the danger of unfair prejudice, confusion of issues, or misleading the jury. By the way, look at this footnote. You know how much I like footnotes. Significantly, the state's assertion that the main character of the book was utterly miserable and stuck in the fictional city runs directly counter to how the book concluded. Now, I'm not sure how that's helping their position because of, maybe at the end, there's a happy ending at the end when maybe that person in the fictional husband died. Who knows? But to say that that's not how the book concluded is not, I don't know if that's going to help your cause, if that in the book she's utterly miserable and stuck in this fictional city. Anyway, wherefore the defendant Donna Adelson respectfully requests that this honorable court grant this motion in limine, prohibit the state from questioning Ms. Adelson, Wendi Adelson, about the storyline of her book, and for such further relief as is just and proper. So what's the new information that's being brought to the attention of the court? Just these dates. The dates that the petition for relocation was denied June 18th, 2013, that wasn't brought up in the original argument. And therefore, since the petition was denied so much after this book was written, well, then this book should not come in at all. So what's my take on it? My take on it is that this motion is most likely going to be denied. Why is that? Well, it doesn't automatically have to be connected directly to when the petition was denied. She could have been feeling this sense of being trapped in Tallahassee even before she filed a petition for relocation and even before the petition for relocation was denied. She could have been feeling this for years. And that's why she's writing about it, because she just feels that she's just stuck in Tallahassee. And that's the feeling that she continued to have while she was writing this book. And then, of course, additionally, it resulted in some petitions that were filed with the court. So that argument, that link can still be there, that connection can still be there, even though technically the petition for relocation was not denied until June 18th, 2013. So they are bringing it up again. Most likely, my take on this is that this motion for reconsideration is going to be denied, but it's an interesting another part of this case. So again, we are going to be still following the Donna Adelson case, see if anything interesting comes up. If it does, I'm going to let you know about it. Any interesting motions, we'll try to let you know about it. Certainly any interesting hearings that happen, we'll try to let you know about that and give you my analysis. But until then, join us tomorrow, again, March 25th at 11 a.m. for a should be a very interesting hearing in Karen Reed's case. So until then, we'll see you all tomorrow, 11 a.m. right back here for more analysis. That's going to be it for now. If you haven't yet, please subscribe, like, and we will see you next time.